So we should be broadcasting now. Before I jump into the presentation, can anybody, type into either the chat panel or the question panel? Let me know that you can hear me. Okay, looks like we're good. All right, good evening, everybody. This is Brad Micklin. I am beginning my monthly webinar, which tonight is Family Law Matters During the COVID-19 Global Pandemic. I'm trying to do a few things simultaneously, so I'll just take a second to explain it. I have my webinar where the registration guests are watching the PowerPoint. I'm going live on Facebook in sort of like a podcast version, and I'm supposed to be streaming live to my YouTube page. And I do this because I record these also and I put them on my site, my YouTube, but sometimes the recordings come out right. And I didn't want to lose the material because I think it may help a lot of people. I also have a tremendous windstorm in my area because I live on a mountain, so it may be messing the audio up a bit. I apologize because there's just nothing I can do about that. So let me begin. Hopefully those that are watching will get the information and can hear me. Don't check the panel during the presentation, so if the sound goes out, I won't really likely know, but hopefully it won't. So let's begin. As I said, this is my monthly webinar. I am doing it this month on family law matters during the COVID-19 pandemic. The webinar is intended to be 60 minutes. It usually goes about that time, but this is one time I'm actually not going to time it. There may be a lot of information, and I don't like to rush through it. So if you need to sign off before that, I apologize. It will be on many different versions of my social media and my website at some point in the future. It is a one-way communication, at least to the webinar registration guests. Hopefully you can hear me, but I can't hear you. I will take questions at the end. I usually recommend you include them in the chat panel, which you should have usually on the right side of your screen to the people watching through GoToWebinar. I will take as much time as necessary to answer all of them. There's also a handout that you should see attached to the panel that you can download or save. It will have, obviously, the PowerPoint. We're talking about all the citations that go inside of it. So without further ado, those that haven't worked with me before, this is me. There's Brad Micklin. I am an attorney in New Jersey. I'm the managing member and lead attorney for the Micklin Law Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law matters. Offices in Nutley and Montclair, New Jersey. As I said, we do focus on men's and fathers' rights. I used to be a general practice attorney. I opened in, 2000. And I quickly found that you really just can't serve everybody well, so I began to concentrate my practice. And about 5 years ago, started focusing solely on men's and fathers' rights. Before that, we were a divorce and family law firm. Here, I put up a couple awards that I've been fortunate enough to receive, not because I'm trying to impress people, but I'm trying to impress upon people that I have been doing this a long time. I put a great deal of care into what I do, and I believe and hope that I'm well qualified to help you through these issues. Next, also, many may know I've been a national legal consultant and media advisor for the past couple of years. I've been on Fox News, Inside Edition, Larry King, and a bunch of others. I do that because it's fun. It doesn't really have much to do with my divorce and family law work, but sometimes it's about family law. It's just fun to be on TV. Hello to a friend of mine signing on Facebook. Appreciate the support. You're here just for support. I never acknowledge anybody by name because I never know who else is going to see you or know that you were here. And if you don't have mutual friends on Facebook, they won't see that you're here. But good to see you anyway. So before I start going through the PowerPoint, the issues tonight are going to be kind of widespread, and they're developing over time. Nobody's really certain about the overall ramifications that the global pandemic caused. Nobody knows the long-term state of the economics, nor do we know how long it'll be until we start even discovering what they are. So the purpose of this is really to kind of tell you where I think we are right now and where we're going in the short term. Long term, things may change, hopefully for the better, obviously. I do believe that. I'm an ultimate optimist. But I'll tell you where I think things are. And as they develop, I'll be doing more presentations like this, both in my daily and weekly tips as well as the monthly webinars that I do here. So let's talk about the first thing that's facing most or many, and that is job loss and possible modifications of support, both child support and alimony. One of the most pressing issues people are beginning to face. So a couple of different things to realize as we talk about what New Jersey is likely to do when it comes to all the people who are going to be seeking to modify their support. And the first thing is to realize it's not going to be as challenging as it may have been in the past, in my opinion. The courts are allowed to do what's called take judicial notice of certain facts and issues. So it's mandatory that businesses shut down. It's mandatory that people stay at home, and a great deal of people are not working. You don't need to bring in proofs to establish that that was the overall state of our economic standing at this point. The court will be able to accept that because they're aware of the facts, and you only need to talk about what your own independent effect was, meaning you don't have to prove if you're, let's say, a real estate salesman. You don't have to prove that the real estate economy or market declined significantly, because the court can take judicial notice of that. You need to establish how it impacted you. At least it relieves half of the burden you would have otherwise had to meet in any other economic condition. Now, it doesn't mean that the court has to accept that as affecting you. They only need to take judicial notice of the economic impact. It's still going to be up to you to present evidence to show how it affected you and what the overall outcome of your income or your support issues were at that time and at the time that you filed. So let's go talk quickly. No, not quickly. Let's talk a little bit about Alimony Statute, which is cited up here as 2A:34-23 for those either on my Facebook or YouTube, if you want that site. All right, backwards. Hard to see the screen in this lighting. I'm not used to doing this from my home. So the typical standard for modifying alimony is a material and substantial change in circumstances, some employment, medical issues, and the like. Now, that's obviously going to be the question here, but the main factor is first the length of the loss or decline of your unemployment or underemployment. Now, it's not the only factor that a court will look at, but it is going to be the first main factor that they need to consider. Now, there are several factors in the Alimony Statute. I'm not going to go through all of them. A lot of issues with regard to specific modifications of alimony. I do have other webinars on my YouTube page and my website, which is micklinlawgroup.com. So I won't go into that. But the important thing to get at this point in the webinar is you need to have experienced this loss or decline in income for at least 90 days if you are an employee working for somebody. The reason is they don't allow modifications for what would be considered temporary changes of circumstances. And the courts arbitrarily decided that 90 days suggests that it is not temporary and moving towards long term. It used to be 6 months. So fortunately, the arbitrary number was significantly reduced a number of years ago, long before the global pandemic, but it will hopefully assist many of you. The thing to realize is it's not necessarily 90 days from whenever the quarantine began. It's going to be 90 days from the time that it impacted you. If you can hear in the background that noise, the wind, it's brutal up here. I've never seen anything like it. So you need to wait the 90 days from the date of the impact. That is going to be different for everybody. I just had a client who actually lost his job a couple months ago, but got a severance for 3 months. My opinion was his loss of income began on that day, even though he had the severance, because he was terminated. So he may be a little bit ahead of the game, but we won't know until he is able actually to file. One good thing about the statute is there is the court's ability to grant what's called retroactive the date that you lost your employment. They have two options, well, three. One is not to do anything retroactive and do it just from the date of the decision. You can do it retroactive from the date that you file the motion, in case it may be a couple months before you get heard. They can do it retroactive to the date that you had the economic impact. You want to ask for that, obviously, because it's going to be the longest. And then the alternative, ask for any other potentially retroactive, because the longer the better. And you can always ask for things in the alternative. Move on a little bit more about the Alimony Statute. It's a very complicated, thorough statute. I put the citation up here in the PowerPoint for you. There are different standards for self-employed individuals. There always have been. The issue for that, even before the pandemic, are that people who are self-employed often have different types of income. They have some control over receipt of income and reporting of income. They get perks that some do and do not pick up as income. So if you're self-employed and your business is declining, just know that the standard is much more rigorous for you and that you should start planning it out, probably with the help of an accountant would be a good idea, so you can actually show the impact properly as well as how you report and pick up income. Now, like I was saying, courts do have a lot of remedies in addition to just the retroactive relief. They can temporarily suspend your support, can temporarily reduce it. They can have it paid through other assets like retirement accounts, 401ks. They can, and I always ask that you get a periodic review in case you are not getting the full award, so that if your circumstances even get worse after, you can go back. And then there's always a catch-all phrase of any other relief being fair and appropriate. One thing inside of this also to consider asking, this I was just speaking with a potential client about doing this. Many people who are paying alimony right now are paying under the old statute or the old tax code where it was tax deductible. So I've recommended to some people recently that they consider offering to pay through a consent order, because you always have to modify your agreement. Instead of making a tax deductible alimony payment, make it a non-tax deductible alimony payment so that you can pay out less money, but later you won't get the tax benefit, but the payment that you have will be smaller, and the person who's receiving it will be getting less money but won't need as much because there won't be a tax burden for them. It gives both of you some breathing room that may be better than what a court may be able to do for you. And you can also ask the court for that. The court does have the power to modify and have it be non-taxable as long as they work on the numbers and make it equitable to each side. Now, the issue that I hear questions about every day since this happened and every day since is parenting time problems. Some are calling because they can't get to see their child. Some are calling because they don't want to take their child because of risks. So it's a very common, very difficult situation for all sides. This is not just a men's and fathers issue any longer. So let's first talk about temporary modifications. It's probably going to be considered by courts and judges currently appropriate to modify parenting time because of the change of circumstances because of the pandemic. It's hard for any parent to guarantee the safety of their child when they're being transported to different houses They're seeing different people. The people they're seeing have been out seeing other people throughout the day. So you don't know what risks are coming in and out of the household. But that doesn't mean that your concern allows you to change your parenting time either, because you still have a court order and you're bound by it. You can't just decide because there's a pandemic the court order no longer applies to you. Just like if you were the parent trying to get parenting time and paying child support, you still have to pay child support. Nothing changes until the court changes it or until you make an agreement to change it. The point I'm making here is that many judges will use or will believe that the pandemic is a sufficient reason for changing parenting time. If there's a parent or a child who is either noticing symptoms around people that have symptoms or at high risk, they have asthma, maybe their parent works in New York where there's a high percentage of affected people, this is an appropriate time to make an emergent application if you want to modify time. Because as I said, you can't just do it on your own. Now, generally, before the pandemic, parenting time issues, child support issues, things like that, they were not considered emergent matters. Emergent matters were more like child abuse, relocation out of the state or country, and issues about parenting time and child support financial issues were not deemed emergent. That's changing given the gravity of circumstances and risks that people take because of the virus. Now, the courts in New Jersey are open and accepting applications, both standard, traditional applications, and emergent applications like we're talking about. The procedures for filing each are separate and different. Emergent applications are primarily used by email or accepted by email, where regular applications are done by delivery service or regular mail. I think you can go to the courthouses for like a drop box, but nobody's being allowed to enter the courthouse except possibly the staff. Hearings are being conducted by phone and by Zoom applications. Some judges are doing them in the courthouses, some are doing them at home, but they are open, functioning, and accepting these applications. If you are having a parenting time issue and it is an emergent one, I recommend that you seek to file an application as soon as you can if you're not able to resolve the issue with the other parent. Let's go on to the next slide. So there's obviously going to be a lot of collateral effects by the parenting or the quarantine that will affect your parenting time. Daycares are obviously closed. Your daycare providers you've been using as babysitters, house care, housekeepers, you may not be able to use them. There may be an objection from the other parent. If you are using them, I would recommend you open a dialogue so that you can discuss this, so you know who is coming into the house and who is not. Healthcare workers are some of the highest risk. So if you have maybe an older parent or you're living with your parent and they have home healthcare aides, I would consider doing what you can to eliminate at least their need to enter the house or their contact with the children. You may want to consider shifting more of the parenting time to the other parent, avoid that risk, and also avoid any issues with the parenting time schedule and the children. There are going to be circumstances where you're going to need to work out and resolve issues, like if you are an essential employee and you're out there working, you're on the road, you're traveling, you're encountering other people. Even those that are working from home still need to realize that there's going to be an impact into the schedule. The other parent may have a different schedule or may not be working. It might make more sense to have them take more parenting time than the person who's working, especially if they're going to be out and exposed to greater risks. If you are going to, even whether you're making an agreement to change your parenting time, you're filing an application for parenting time, I always recommend that you ask for makeup time. One parent in most of these circumstances is going to be losing a great deal of parenting time. I've been talking to dozens of people who are simply being prohibited from seeing their children, and there's really not much you can do in the short term, because like I said, if a parenting time issue is not the emergent issue that I was talking about. Emergent issue I was talking about is the risk to your child. So parenting time issues will take you probably months to get resolved. You do want to ask for a make-up parenting time. You may want to consider a modification of child support if you were paying for daycare or extracurricular activities that weren't being utilized or incurred during this time. Entirely appropriate. I do recommend, first, because I think it's better for cooperation that you try to work it out with the other parent, but also anticipate there's going to start a backlog of applications. First, when the pandemic first hit, the courts just shut down. They weren't really prepared for how to handle all this. They didn't have video conferencing, they didn't have electronic filing, and they had a load of cases that were ready to be heard. Everything stopped and everything got kicked down the curb, the street. So there was already a backlog that was beginning. There was already a backlog in the family court to begin with. And the cases that got stopped got backlogged. Then the process that they started to hear them started to get backlogged. So now we have a whole load of cases that have been pushed down till a later time period. Couple that with the fact that I think there's going to become a lot of applications in the next month or 2 or 3 to modify support, to change parenting time, and to get back missed parenting time. So you're going to have twice as many cases coming in and twice as many that have been sitting that need to move first. So long and short of that is, if you have an issue now, get ready to have it filed so that you don't get that far back. You want to get into the queue as fast as you can. I want to do a quick check. So I see some people signing on Facebook. Hello, glad to see you. Like the support. The information helps you or somebody else. And anybody in my webinar, just give me a post to let me know if you can still hear what I'm saying before I move on to some more PowerPoints. Into either where it's the questions or the chat panel. Let me go back. I'm not seeing. I get concerned, but I'm also not the best when it comes to managing this panel. I usually just start my webinar and don't pay any attention to it. I would like to be sure that everybody's hearing me. I'll go on the assumption that you are hearing me. And we will move on. All right, so another issue that parents need to resolve, if you can't on your own, you're going to need to resolve it with the courts, and you may want to consider putting it into this application. And that is going to be, how are your children being educated? Most, if not all, schools and curriculums have initiated a virtual learning process that does require parents to be involved and facilitating that. If one of the parents is working, possibly quarantined in some other area, or unable to access this information, we need to know how to address that. Given the fact that this quarantine could last for a couple months longer than we know right now. Just like every application we're talking about, I don't recommend, I should say, well, negative, recommend that you file as soon as you realize you have the issue if you're unable to resolve it between the two parents. This next point is an interesting one. So I'm generally recommending, if you had a pickup and drop off at a public place, police station, firehouse, shopping mall, it's usually done because there's been some high conflict issues or domestic violence in the past. If there's a domestic violence restraining order in effect, then you still need to go to the police station or the public place that was ordered, unless that restraining order itself is changed. So I'm not talking about that specific circumstance, but there are many other people that have a police station or a fire station as a pickup and drop off, and it's not a good idea because of the number of people that are coming in and out, and obviously the type of people that they're going to be in contact with are going to be high-risk people. It's another issue you need to address through either the cooperation I'm talking about or the application that I recommend you file. You should also consider modifying time. Don't be so rigorous to standing by while I'm supposed to have, pick up at Friday at 4 o'clock after school. There is no school. You might want to pick up at 12 o'clock, but bring back a few hours early. You might have 50 days. You just want to minimize all of your exposures, parents and the child, and anybody you're going to come in contact with, by modifying the schedule temporarily. Like I said before, and I'll keep saying it throughout this, you can always agree to something that will provide for makeup or change of schedules in the future. But right now, you want to minimize everybody's risks so that you can get back to normal as fast as possible. I put up here a case example that I had. It's interesting because the one up here that I'm putting up was about a trial court judge that we filed an emergent motion for because our client had the children in like a rural, suburban kind of area with no COVID cases reported for like a 50-mile radius. The court ordered the child to be returned to keep in compliance with the parenting time order that was in place. Now, that was earlier into this pandemic. We recently had a case where it was the opposite decision. I have a client who had parenting time in, I guess I would say, in more of a rural area. It was in Pennsylvania. No offense to the people watching on Facebook from Pennsylvania, because I'm from there too. It is more rural. And the court in this case ordered the child not to be exchanged for parenting time at all for the course of the pandemic. Now, that case also had a final restraining order in place that could have impacted the decision. I think it was because the case was more recent than the one I'm putting up here. And I think as things get more serious, judges are erring on the side of caution and leaving children in the home where they are, not transporting them, not coming into contact with other parents who may be in contact with other people. That's important to realize because, as I keep preaching, you want to try to resolve these issues. The longer this goes, the more severe it becomes, the less likely the court's going to give you enforcement in the middle of the pandemic. So you might be waiting a lot of time, affecting your relationship, not getting anything at the end of it. It might be wiser to realize that and to act now and try to resolve it in everybody's best interest. Because it's just too early for us to know how any of these things are going to turn out. So let's turn now to some tax issues to keep in mind during the pandemic. Filing 2019 taxes have been extended until July 15. It's important to family law because there might be dependent deductions, child care deductions. There might be issues with joint filing if you just got divorced. There's a lot of issues that fall into an annual tax return that you may not have been able to resolve because of the quarantine. It's only to July 15th. You should still get on that because, again, you don't know what's going to happen. And while you have the time in your home, assuming that you're home, I see some family signing on. Welcome. Sorry, my Facebook pages. No, I think my title comes out of order here. So temporary changes and modifications in custody and parental time. We've already talked about that. For safety of the children. Mortgage payments. This may be more of an individual basis. There have been a lot of mortgage companies that I've heard of that have been giving a sort of forbearance on their payments. There's also bound to be in the coming months programs to allow to backload missed payments or to consolidate your mortgage payments. It's going to be important because it's going to change the reporting of your mortgage interest. Probably not 19, but it will for this coming year. Now, the stimulus plan, I'll go through this real quickly. Let me just put on my slides, because I'm not going to go through all the specifics about income levels and who gets what. But I do want you to take a second and just read the slides, the earning levels and the stimulus amounts first, because it's money. But more importantly, I've gotten a few calls recently to figure out what to do with this when the stimulus check is for a child. And I've said there's really just some practical ways of looking at it. I mean, either you keep it, but the other parent keep it. You can split it, or you can divide it proportionally to your income. Now, if I had to guess at what a court would do in a dispute, over this. First, they would tell you you shouldn't be there disputing over it because it's not worth the time. But if you were there disputing it, I think the court would do it on an income proportionate basis, because that's about how child support guidelines resolve issues about extracurricular activities, unreimbursed medical. So I think that's where the courts would lean, unless the incomes themselves were fairly comparable, close enough where they would make an equal split. But that's really my common sense approach. You take whatever you think is going to be best, keeping in mind the long-term goal may be to get more parenting time or to preserve your relationship. You may need to sacrifice a couple of dollars in order to get that. Who knows? So let's talk a little bit more about how the courts are prioritizing cases currently and in the future, as I touched upon a few moments ago. All right, so first, there's no in-court hearings at all, emergent or traditional. You can file an emergent application, like I said, by email. There is a link on the judiciary website. I don't have the site offhand, but if you type into a web browser, New Jersey judiciary website, bring it right to it. Give you the email addresses for each county's family emergent matter inbox. So you can email. You do still have to serve your adversary, the other parent. Court rules say you're supposed to serve them by regular mail. The ironic thing is that email is not currently an accepted method of service papers. But email is more likely to ensure prompt notice and actual notice. Regular mail is still going to be slow, especially with the no contact provisions in. So I've been doing both. When I file an emergent application, I email and regular mail it, because it makes no sense to comply with the court rules. They're outdated. I mean, the whole family court system's been outdated until this quarantine hit and they finally started getting electronic filings and video conferencing. They should have had them 20 years ago. So it's up there. Link. I went a little ahead of the webinar PowerPoint. But here we go to what I was talking about before. A lot of cases are being postponed in the backlog. My belief is that it's going to get worse, and it's probably one of the more important things to consider if you have an application. Because I talk to people all day long now, because everybody's got this belief that like divorces are in tremendous rise, and not necessarily the case just yet. Conversations are on the rise because everybody's stuck under the same roof. So people are inquiring into it and they're calling. It's still a long process. And I'm not trying to promote business. I'm just telling you the way it is. The longer that you wait to file anything, whether it's a divorce or for make a parenting time, the longer it's going to take to get the issue resolved, because there's going to be a substantial amount of filings coupled with the backlog that we've been experiencing. Most hearings are being done by phone or video conferencing. I recommend everybody download the application Zoom. As my friends and family on Facebook know, I like to use it for social media party on the weekends, but it's also a great application and one that the court's using. One thing the courts haven't addressed yet is, if this continues, how they're going to do trials. Now, video conferencing is easy. Everybody gets up and either on the phone or in a video, and you can argue. But when it comes to trials, you have to mark evidence. You need to be able to hand your witness documents, examine the use of other physical evidence. And I don't think they're really prepared to address that in a way that guarantees there's going to be fundamental fairness in the process. I think if they start doing trials without an ironclad policy for admissibility of evidence, you're going to have a ton of appeals. So you're going to get bad decisions, appeals, and even more of a backlog. So right now they're not scheduling any trials, which is a scary situation to be in, especially for anybody in litigation. I mean, these issues, many people don't think of certain things. Like those of us in the profession don't often realize how serious these issues can be for people. But you have people, personal injury cases waiting for trial. You got tenants that are maybe getting evicted. It's just without trials, nobody knows what's going to happen next, and it's got to be a very frightening situation for many people. Speaking specifically about family law cases now, those of you that are in the divorce process will have or have had something called an early settlement panel, an ESP. As of this week, all the ones that had been previously scheduled up to this week had been adjourned, definitely. Now, they are starting to move them. I've noticed a few of my cases have been scheduled for early settlement panels. They will have you email a panelist for submissions and have a phone or video. Now, one I participated in just recently only had the client, or only had the attorneys, didn't have the clients. For me, that was my preference anyway. Truthfully, it's not a very good way to hold a settlement conference, because what's the point of talking settlement if the clients aren't there to participate? But they gave me the option. It was better for us. But I think they're going to start including clients through the Zoom application. It's not that difficult to coordinate. Dismissal of cases. Now, in family law, cases can be dismissed because they haven't served the other person in time, or one person didn't comply with something in time, or there was a deadline set that lapsed. Those are being pushed back again up until this week. Most of the dates were pushed. I haven't heard what's happening going forward as of the 1st, May 1st. Oh, by the way, I didn't mention it when I signed on that this is being filmed on April 30th, 2020, just so that if you're watching this in the future, it's all going to be different. Sorry. So getting back to the dismissals, they've been pushed back until this week. That doesn't mean that everything that was pushed back to this week is being dismissed. That just means it's sitting in this black abyss of dates waiting for it to be scheduled, and we just don't know when anything's going to be scheduled. Discovery, which is the exchange of information inside of the divorce case, questions, documents, depositions, have all been extended and pushed back. But more importantly, the rules regarding the dates and deadlines have been relaxed and extended indefinitely. Courts have just recently been scheduling case management conferences, which are scheduling conferences, to start addressing these dates because they realize there's only so long they can let matters sit. So that is starting to move. Divorces are starting to move a little faster, I think, than custody and parenting time cases have, because there's a greater complexity to them. I think that the focus is on moving divorce cases more rapidly than custody and parenting time. I haven't heard much about domestic violence cases other than they are on the rise for unfortunate, obvious reasons. Depositions are being permitted, but they have to be remote. Again, that causes a similar issue with trial, that part of a deposition is often about showing the side to expect at trial, which means you want to cross-examine, you want to show damaging evidence, you need to have exhibits marked and shown, you need to see body language. So while they're being permitted remotely, I don't think it's effective. And I've pushed my depositions back until they can be done at least more appropriately virtually, or once the pandemic is over, because I really don't think they have the same effect. Appearance for medical professionals responding to COVID are suspended. So if you are in any way related to medical professionals, police, fire officers also, I would believe fall under this. Anybody in high demand and at high risk at the same time will be granted leave of appearances, will be reasonably granted a lot of leeway with scheduling and dates also. The time period from March 28th through April 26th has been deemed a legal holiday for the purpose of commuting filing. Why that is you have the unfortunate, you need to read the court rules. There's a complex rule, I think it's like 1:1, obviously. It sets forth how you count filing dates. Many of them are based on trigger from something filed before it. So for instance, if you get a motion, your return response is due a certain amount of days from the day you got the motion. So where the rule calculates those days to respond, they don't count legal holidays. So by saying March 28th, April 26th is a legal holiday, every single thing had a filing date, response date, any kind of trigger has been extended by that equal amount of days. Courts have finally come into this century and now forced to accept electronic signatures like a DocuSign, even if you sign through like a PDF, a markup, They previously didn't accept that. We'll take that now. So let's talk a little bit about options that you have, at least to the extent that we have it already, and that may kind of duplicate some of what I've already talked about. But for those that are choosing to move forward on a divorce during the pandemic, you can start the process from home. It has now become virtual. My firm almost immediately changed our whole policy over, and I think a lot are following suit. Documents are signed electronically, video conferencing for all of our meetings. Our calendar is now virtual. You go online and schedule, so you don't have to go through staff because we're all working remotely. The court is also expanding their electronic filing, which they'd never had until this point. At least the family court never had it. Federal court had it. I think civil court had it. And criminal. I think family was one of the few, if not the only, that didn't have it. It was ridiculous. They should have had it 20 years ago, but they finally now do have it. So you can take electronic documents and file them electronically. It's not a complicated process. You can just type again, New Jersey Judiciary Electronic Filing. You'll get. So I'm not sure if it's for pro ses or if it's just for attorneys, because I wouldn't have reason to have known that. I am an attorney, so I guess you'd have to research that. I'm sorry for not having that answer. What's next? I don't know if you can hear that wind in the back, but I've never heard it like this before. It's horrible. You'll be providing online information to your attorney. It is all confidential. It's all encrypted. Now, what to expect when you do file? So, again, temporary suspension of the dates, electronic signatures, phone calls for all of your conferences, like I mentioned, electronic scanning of documents, which is important for those that may not have this technology. You want to start to update it because, again, we don't know how long you're going to be here. You can have a scanner delivered to your house. Start to learn how to use things like DocuSign, PDF formats. Another thing that you're going to need to look at is, and this I think may become a significant issue inside of divorces, is how do we analyze both support and distribution of assets? It used to be from the data filing was kind of like the cutoff. But first, we're going to have a significant change to both incomes and asset values. We also may have a significant delay from the time of filing to the time of the case to get resolved. And I think you need to be prepared to discuss alternative ways to view this. We can't just take our traditional approach of looking at what the papers say, the tax returns, the bank statements, credit cards, and retirement accounts, and just figuring it from there. We really need to be a little more creative, to make sure that it is being done fairly. You can still file if you're living at home. It's obviously a challenge. I've had a lot of people who are speaking to me from home, and they have to go into their car, and it's awkward, understandably, but it's necessary. And I think it's therapeutic, to be honest with you. I think to avoid these conversations, very dangerous. And if you're living in this pressure cooker and not discussing with either each other or an attorney, I think you're just waiting for a disaster. Now, as I've been saying, I expect the process, all cases, to be slow. Now, the divorce process may not suffer as badly because the process itself was slow. So, for instance, when you would file a divorce before the pandemic, if you filed in January, you didn't get the papers to the other side until February. It might be March, April, even May before the courts would give you your first conference, which would be a scheduling conference, which would then schedule you 3 more months out. Quick hello to everybody signing on. Thanks for the support. Love seeing you guys. So had a 3 to 6 month window before anything meaningful would happen in your divorce case. That's not going to be so dreadfully impacted by this backlog, because I think once you start the process, if it's relatively soon, you'll be in the waiting period anyway while the backlog is being caught up. So it shouldn't be as bad long term. It's really the immediate process that's going to be difficult. Like I said a moment ago briefly, you really need to look at what is the financial impact to the salary levels, the future income for both support, alimony, and child support. Again, you may need to be a little more creative when analyzing future, like you may be agreeing to a support now. and have no idea what's going to happen in 6 months, where it used to be we would review taxes, let's say every 2 years, child support and alimony 2 or 3 years. We might be doing it every 6 months now or every year. We see where everything goes. And I think you're going to be required to have more creative and unique parenting time because of the stay-at-home orders and the difficulties in commuting and the risks of having other people involved. We need to sort of step out of our old divorce box with all these issues: parenting schedules, division of assets, alimony. It's a whole new world there. So just like before, there are also alternatives to going through this possibly dreadful long delay. They're generally considered alternate dispute resolution forms. First is mediation, and I'm not going to go into a great deal of information. I do have webinars on all these separately. There are very intricate areas that you want to learn more about, but mediation is really where you have a third person, well, usually a third person, helping the two of you resolve your agreement between you two, meaning you make the agreement. So if alimony is an issue, you tell what you want to pay for alimony, the other person says what they want to accept. You have a mediator try to make you reach an agreement. As a quick side point, I'm not a big fan of mediation because most mediators don't do it right, and it's problematic. Mediators, it's very taxing to mediate a divorce, so many of them try to impress on you what the law says you should be doing, which isn't mediation, more like arbitration, right? Somebody's just making a decision. Mediation is for you two to make your own agreement. The important thing to know about mediation is that it does not require that you follow the law. You do whatever you want, as long as it's not against public policy or harmful to your children. You agree to anything. Don't let anybody tell you that you have to do something because you're in mediation. That's the whole purpose of being in mediation. Collaborative law, that's also an interesting thing. It rose in popularity a couple of years ago, and then I think it quickly died, in my opinion. But it's not that it's not around. It's just many people use it. The collaborative law is where the two parents, well, usually parents, but it could be just husband and wife, spouses, let's say, and you agree to a process that is confidential and geared towards working to shared goals. So if you and your spouse have a child and your goal is to have maximized time together and minimize the impact to your child, you hire lawyers, you each hire your own lawyers, hire joint experts like custody evaluations, accountants, and you're all supposed to work together to this one goal. And if you do not reach that goal or there's a breakdown in it, all the people involved no longer be involved. Everything remains confidential, but everybody's out and start over with new people. I'm not a big fan of that either, because if you had two people who are truly committed to working together for a common goal, you don't need all these people involved. You're only going to have these people involved if there's somebody who's trying, or both people are trying to exert their own position or take influence in the situation. Collaborative law only works for people who don't need it. People who already are collaborative and accommodating and working towards a common goal don't need it. So beware of getting into that process unless you really truly do share the common goal. Then there's many informal settlement methods. The divorce process itself is largely mediation. People think that there are all these, town, battles, and they're not. Those are the aberrations. I always make the analogy of, I don't know, like 20, 30 years ago now, that person who spilled coffee, Dunkin' Donuts coffee, got like $3 million. And everybody thinks, oh, if I get injured, I'm going to get $3 million. But that reason that you hear about that case is because it's the aberration. You don't get $3 million for coffee. You get like $3,000 if you're lucky for a bad burn. It was a third-degree burn, by the way. So people generalize the legal system off of the few things they hear, and that's really not the case. So the divorce process is almost half of it is mediation types of processes that the courts put you through. You can do almost anything that you think is going to help you bridge a gap, resolve an issue, and move on. You don't have to resolve all your issues. It can just be some, maybe one, but any one that you resolve is just less litigation that you need to have going forward. That, I believe, is the end of PowerPoint. And I'm going to see if I have any questions in my chat panel or in the, I never know if it's in the question section or in the, let's see, I'm going to try to expand the window, but then what happens is I can't see the PowerPoint. I'm going to do it anyway. and that's not working. I see a comment here. I think they're saying I am the wind because the wind here is just, like I said, I've never heard. I don't know if you can hear it or not. What I hear is almost unbearable. So let me see if anybody on Facebook here put up a question or not, because I think you can comment there. I don't think so, but if you do, obviously you can post up here. If you want to message me, it's great too. I'm always available. My email, which all of you should have, is Brad, B-R-E-D, Micklin Law Group. That's M-I-C-K-L-I-N, lawgroup.com, all one word. I'm going to take another minute just to see if I can open this. I'm usually, oh, here we go. All right. So we do have some questions. Okay, so can I repeat what collaborative law is? Yes. And, for the person that's tuning in, I'm assuming that they have that in other states, but this is in New Jersey. Collaborative law is where the two parties decide that they want to enter into a confidential settlement negotiations because they believe they share goals, outcomes. So it's a unified approach to resolving your issues. You each can have your own lawyer, or you don't need to have your own lawyer. And whatever professionals that you need to have, like mental health, social workers, forensic accountants, lifestyle analysis, are going to be joint experts to help you resolve the difference. And I guess you could each have your own too, but it really wouldn't make any sense. So you hire your professionals for whatever your issues are. You explain to them what your goals are, and they try to help you reach them, either doing what their analyses would be or helping you mediate. For instance, if you had a lifestyle and your goal was to minimize the costs and to keep a comparable life, you would largely want to accept whatever the forensic accountant determined to be a lifestyle. In a traditional case, if you had a lifestyle analysis and you don't like it, you'd go get your own. So the collaborative law is everybody's working together in this little group. But if it breaks down, or you change your mind, or you're not happy with it, then it's over. Everything that happens is confidential. None of the people that were involved can be involved in the process going forward, and you have to get all new people. It's a very difficult process when it breaks down because you've had professionals that you've paid for, you've gone through a large part, if not all, of the process, and then when it breaks down, you start over again with all new professionals. Not a fan of it. It really only works, again, for people who don't need it, because people that committed to working towards a goal don't need it. It's my own personal opinion. I'm not knocking the people out there. I know there's lawyers who do just collaborative law. All power to you. I hope it works, and I wish you the best of luck. I'm not a fan of it. All right, so maybe you mentioned if a court agrees to change parenting time for good cause, it potentially would make up time in the future. So the question is, if parenting time is changed now, would they give make up time in the future? I think so. It's going to depend partly on why it's being changed and how much is being changed. I think if there's a fair amount of time being lost, then there's going to be make-up time. So what I mean is, if you are quarantined for 2 months and the other parent hasn't seen the child for 2 months, I think there's going to be a month or two make-up parenting time. Doesn't mean they're going to get the child for the next month. They may just get an extra week here, a week there. They might get more time in summer. They might get more holidays. There's a lot of ways to do it. But I think they will give parent a make-up time if there's been a loss of parenting time. Absolutely. I don't see other questions there. I'm going to quickly check through my other apps, see if anybody on YouTube or my Facebook have sent messages. And I'll leave the webinar running for another minute in case anybody else has some questions here before I sign off. I've been happy to answer any questions you got. And then, of course, you can also message me after this. All right, I'm not seeing any. So thanks for tuning in. I certainly hope the information helps you or people you know. If it does, please give a like and share it. If you're on my YouTube page, you can also subscribe so they get noticed when I go online. Wind's kicking up again, so I got to move closer to the mics. Sorry if the sound hasn't been the best because of the wind. There's nothing I can do about it. I'm quarantined also. I had to go from there. I will be on next month. Let me actually tell you, I could never do this in the past because I only had one device opened, but if I can get my next webinar is May 28th, 6:30, how New Jersey fathers can modify child support orders. Something that we touched on lightly here. We'll go into great depth. If you have questions about that, certainly message me at any time. You can go onto my website now, onto my webinars page, and register at any time. It'll be up throughout the next month. And I just wish everybody good luck. Hope everybody stays safe and have a good night.